Hi, welcome to Wilson Spills, where I debunk common wills and estate myths over one cocktail at a time. The cocktail I'll be making today is called the Long Island Iced Tea, and the myth is the deceased property was gifted to me in the will, and you cannot challenge this. Now, to help me debunk this myth, I've got Joseph Acutt with me, who's an experienced barrister in this area of law. Thanks for joining me, Joe.
Well, thank you very much, Linda.
Now, so we have been involved in cases where deceased has gifted a property to a beneficiary, and it's been challenged by people who argue that they have a beneficial interest in the property. So in this situation, a constructive trust may be imposed by the court. Now, can you take us through what is a constructive trust?
Yeah, a constructive trust is really a legal remedy that the court has at its disposal in certain types of actions, like some form of equitable relief, seeking a proprietary or equitable interest in a property. And one way the court can achieve that outcome is by declaring or imposing a constructive trust. So in the context of an estate, the order that might be sought in the prayer for relief would be that the executor, on behalf of the estate or in that capacity, holds the property on constructive trust for the plaintiff.
And what's an example, a common example of that you find?
Yeah, well, one that comes up both in maybe a constructive trust context, but also a resulting trust context, is when a property is left to a child, and then there might be a second partner of the deceased who comes along and alleges that I made all these contributions to the property, and it was promised to me. And in those circumstances, although it's gifted to you under the will, the deceased has effectively reneged on that promise or not followed through. And because of that, based on certain equitable actions, I'm entitled to a proprietary or the beneficial interest in that property. And that's where often there might be an estoppel claim or some sort of breach of fiduciary duties claim, depending on the circumstances. And one of the things that the plaintiff would ask in that circumstance is a declaration of a resulting or constructive trust.
Okay, so if someone's in that situation, what would the person need to prove?
It would depend on the underlying equitable or proprietary or legal action that they're pursuing, because a constructive trust isn't the action, it's the remedy at the end, if that makes sense. So an estoppel claim has its elements, a breach of fiduciary duty claim has its elements, general breach of trust claims have their elements as well, and they all will depend on the circumstances. But because they're often seeking a declaration of that equitable interest in a property, there's usually an element of unconscionability or unfairness that the court will tether itself, will connect to in order to grant that kind of relief.
Right. So if an estate has to defend this, what could an executor do? What are the defences against something like a constructive trust relief?
Well, I mean, they're often hard because the underlying claim is often some sort of equitable action, and there's often things aren't in writing, and it's all about what people remember, and the main witness of the case is deceased. There's usually evidentiary difficulties that a person alleging such a claim might have, but also certain claims have time limits, certain claims don't, depending on that underlying action that gives rise to the possibility of the imposition of a constructive trust. I think too that a constructive trust is a discretionary remedy, like a lot of remedies in equity, and in those circumstances, the court may opt for a less intrusive remedy in terms of compensation or something like that doesn't completely upend property rights. And that's often an attraction to the court. So you may be able to argue that although there's been some breach or there's some entitlement to some relief, the circumstances don't merit a complete declaration of effective ownership in favour of the plaintiff. So that's another thing to keep in mind.
Yeah, well, thanks, Joe. If you are in this situation, it's really important you seek some legal advice from a wills and estates lawyer. Well, let's have a drink.
Oh, thank you very much.
Cheers.